Just welcome everyone to this webinar, to today's webinar. It's good to see so many people, not see, but good to know that so many people are on the call today. So for those that don't know me, I'm Liz Murdoch and I'm the team leader for Youth Justice and Secure Care at the Scottish Government. And I'm joined today by Debbie Nolan, who's one of the practice leads at the Children and Young People Centre for Justice. So this is the second webinar that Debbie and I have delivered on the topic of ending the use of young offenders institutions for children in Scotland, and that's as part of the Children Care and Justice Scotland Act, which came into force on the June this year, or received royal assent in June this year. And the provisions of the specific part of the Act came into force on the 28th of August. And I'm pleased to say that as of the 31st of August, there are no under 18s being detained in young offenders institutions in Scotland. Both myself and Debbie have been heavily involved in the development of the bill as it went through Parliament. In particular, Debbie, as she was on secondment to the Scottish Government in the bill team to support that work. This webinar is a 1-hour webinar, and cameras and microphones have been turned off, but there will be a 30-minute kind of presentation roughly, along with time at the end for questions. So if people can use the chat function for the questions, then we'll endeavour to kind of answer those as much as we can do. So the session is actually being recorded, so it means that people can go in and have a watch again afterwards, or forward it on to colleagues who aren't able to make the session today. And I've also been asked to say that CYCJ have a mailing list, and if you're not on that mailing list and want to be, then please contact CYCJ and to be added to that mailing list. CYCJ have also published information sheets on the Children Care and Justice Scotland Act, and in particular they've got a specific briefing paper on the ending the use of YOIs for children in Scotland, and that paper will be updated following on the back of this session today, on the back of any questions that we receive. So we'll be updating that, and that'll be published on CYCJ's website. But please get in contact with CYCJ if you have any kind of further points of clarification, or if you would like any kind of support with to prepare kind of for implementation of the Act. The CYCJ will be happy to kind of help out with that. So without further ado, I'll hand over to Debbie, who will start and take us through the start of the presentation. Thanks, Debbie.
That's great. Thanks, Liz. And just to echo Liz's welcome and thanks to everyone for joining us today. So the slides will be made available after the input, as well the recording. So don't worry too much about frantically taking notes. But the aims of today then are really to raise awareness of the ending of YOIs for children and the provisions in the Act that did that, as Liz has highlighted, which commenced at the end of August. To highlight the legislative provisions in the Children Care and Justice Scotland Act that enable this change to take place, to outline some of the preparations that were undertaken for this change, and to explore some of the practical implications for children who have been remanded or sentenced. But before we do that, we just thought it'd be helpful to just quickly outline why this change has come around. And I'm sure people will be familiar with the promise and the conclusions of the promise in respect of young offenders institutions, or YOIs. But the promise really concluded that YOIs are not appropriate places for children, and as the quote shows, serve to perpetuate the pain many of them have experienced. Therefore, the Scottish Government accepted this and committed to ending the use of YOIs by the end of this calendar year, which has now been achieved. What the promise did also say, however, in line with Article 37 of the UNCRC, which has been recently incorporated into Scots law, that there would be times where it's right and the only option would be for children to have their liberty restricted. But when this is done, that has to be once all other options have been fully explored. It should be for the shortest time possible, really echoing what UNCRC said there. But also the promise spoke about this should be being in small, secure, safe, trauma-informed environments that uphold children's rights, which is akin to what secure care provides in Scotland, and certainly more akin than what could be provided in YOIs. So the case for change was made really crystal clear by the promise. But in addition to that, there's a clear evidence base that supports this change taking place. So Scottish research was undertaken by colleagues at CYCJ prior to during the development of the bill, and that really found that when they looked at the needs of children in secure care, but also the needs and experiences of children in YOIs, that actually those children had very similar needs, had very similar experience of adversity, and actually indeed these were often the same children. Whether children were placed in YOIs or secure care, they were often children who were taking and facing significant risks, and actually had often, as part of that, had committed acts that had caused serious harm, be that to themselves or other people. So the real similarity of children's experience supported this. In addition to that, secure care centres are already caring for these children. So secure care centres are already operating an integrated model of care. They have operated that integrated model of care for a long period of time. And that integrated model really means that where children are placed through a welfare route or placed through a justice route, they are cared for together. And in doing so, secure care centres have a track record of meeting the needs and managing the risks presented by both of those kind of cohorts of children, and managing them well and in a way that keeps everyone safe. In addition to that, English research, which kind of looked at this, almost looked at the kind of integrated model, really concluded that where children are placed in secure care, be that through a welfare route or a justice route, there was no greater risk to other children or staff dependent on the route. And indeed, that risk was not determined or dictated by even the gravity of an offence that a child, or harm that had been caused by, for the reason that a child had been placed. So really, risk, route or type of offence does not equal the risk that will be presented to other children and staff. And then finally, the data really supports all of this. So secure care centres are already looking after 16, 17-year-olds. Indeed, in our most recent social work children and family statistics from July 2023, nearly half of the children in secure care on that particular date were aged 16, 17. We already have a relatively high number of children placed in secure care through justice routes. So sentenced children since 2014-15, the data has been published, often that anonymised because the numbers of children are relatively small. But in 2021-22, 8 children in secure care were placed there on remand. So actually, this caring for older children and children placed through justice routes is not new practice. The Scottish Government has been funding 16 beds in secure care since 2023, and that was based on the average number of children in YOIs in 2021-2022, albeit that number has reduced. So the promise gave us a mandate to make this change, but in addition to that mandate, it has a really clear evidence base and a really well-supported evidence base. So that's why the change has happened. So now what does this change actually do? What does the legislation through the Act actually do for us? So the Act has a number of the key sections, as Liz mentioned, of the Act were commenced in August to enable these changes to take place. The information sheet that Liz referred to and that Sally has added the link to in the chat outlines the broader parts of the Act, which I think it's just important to clarify. Not all of them have commenced. The only parts that have commenced are the ones that are linked to the ending of YOIs, and the timeline for the commencement of the other parts is still being worked through. And CYCJ will be providing a lot more practice materials, webinars, briefings, for example, about those other provisions before they commence. But what does the Act do for the ending of YOIs then? So prior to earlier this year, prior to the last couple of weeks, there was this anomaly in the legal routes for children and definition of children aged under 18, where they were being remanded or sentenced. If children were 16, 17, their place of detention was not determined by those child's needs. It was very much determined by their legal status or their age, because 16, 17-year-olds who were not on or open to the children's hearing system could not be placed in secure care. Therefore, what the Act does is addresses that and means that all children under 18 who are remanded or sentenced will be treated and regarded as children. And in doing so, it affords a legal route for all children who have been remanded, committed or sentenced to be placed in secure care. Those legal routes that previously existed are not fundamentally changed. So children can still be remanded under Section 51 of the Criminal Procedure Scotland Act, and in doing so, the child can either be remanded, the court can mandate that child is remanded to secure care, in which case that child has to be placed in secure care and the local authority has no ability to place the child elsewhere, or the child can be remanded to the care of the local authority to identify a suitable place of safety. And then in doing so, secure care can be used, provided the other parts of the secure care regulations are met. So that legal route to remand that previously existed for some 16, 17-year-olds and all under 16s now applies for all under 18s. There will no longer be any remands to secure care. Where a child has been sentenced under solemn proceedings, those children will now be sentenced under Section 205 or 208. And those children, when they are sentenced, Scottish ministers will direct where those children are placed. And that placement will no longer be able to be YOI, but in keeping with what the whole system approach policy had been previously, all sentenced children will now need to be placed in secure care if they're sentenced under solemn proceedings. If children are sentenced under summary proceedings, so under Section 44, those children couldn't previously be placed in a YOI. And likewise, if children were to be sentenced to be deprived of their liberty for fine default, they couldn't be placed in a YOI previously, but they could be placed in secure care, and that remains the same. Where there is options, so for sentence under summary proceedings, remand to the care of the local authority to a place of safety, and sentence for fine default, the local authority can decide where to place those children, and the Chief Social Work Officer has specific roles and responsibilities under the secure care regulations, for example, regarding consultation. But if that child's going to be placed in secure care through those routes, the Chief Social Work Officer needs to be satisfied that it's in the best interest of the child, the placement is appropriate to the child's needs, and that the secure care criteria is met. And also needs agreement of the head of unit for the secure care centre as well. So those existing arrangements that have been in place still remain. Those considerations still need to take place. The fundamental change is that YOI will no longer be an option. And as a result, the definition of a young offender in legislation and the definition of a young offender's institutions needed to change. So that means that no under 18s can be placed in those establishments any longer. Lastly, where a child has been remanded or sentenced to secure care, regardless of that child is already looked after, all of those children now need to be treated as if they were looked after children. And that really, that even whatever length of time the child is placed in secure care, but that if children are remanded or sentenced to secure care, they need to be treated as if they were looked after children. That will mean that those children have corporate parenting entitlements, and the roles and responsibilities to look after children apply to those children. And if those children meet the statutory definition of a care leaver, they then would have aftercare entitlements. There are specific requirements to look after children, which are detailed in more length in the briefing paper that has been published on the ending of YOIs, that again Sally has linked to in the chat. So that's what the Act really does. The secure care regulations still need to be read alongside the provisions in the Act, and they will be updated in due course. Those regulations will also include a provision that will allow children in certain circumstances who have been remanded or sentenced to remain in secure care beyond their 18th birthday. However, that part is not in force at the moment because it will need to be developed through regulations, and the plan will be to update those regulations in due course. The sections of the Act, however, have commenced at the end of August, as Liz has mentioned, and that means that Scotland will no longer place children in young offenders institutions. There's loads more information on the Act itself in our info sheet and in our briefing papers, so if you're interested in that, please do look at it. And as Liz said, CYCJ are on hand to provide support on this, so please do get in touch with us about that. The briefing paper on the ending of YOIs will also be updated following today's webinar to reflect the questions and answers given today and also at the previous webinar. So watch this space for an update there. So in anticipation of this legislative change coming, a whole raft of preparatory work was undertaken, and I'll hand over to Liz just to briefly touch on that preparatory work.
Thanks, Debbie. So yeah, and so from the bill kind of passing, becoming an act in June, the decision was taken to commence the provisions around the under 18s and YOI as soon as possible. And as Debbie's kind of mentioned, prior to that, kind of leading throughout the bill, there was a lot of kind of research already done. There were lots of discussions with various kind of key partners, and evidence was provided kind of at committee sessions around kind of implications, I suppose, of this part of the Act in particular. For the last year, Scottish Government, as Debbie mentioned, we've been funding up to 16 placements within secure accommodation, and that funding was agreed for this current financial year that we're in. So that takes us until the end of March 2025. And that funding's kind of there to kind of bolster stability, but also to ensure that we've got capacity for children in Scotland, and also to reduce that reliance on cross-border placements. Now, that's not to say that cross-border placements aren't allowed in secure accommodation. Obviously, that is still possible where it's in the best interest of that child, but it's to ensure that we do have capacity for children living in Scotland as well. To get to the 28th of August date, there was a lot of a kind of work involved in that, and a collaborative kind of effort. And we're extremely grateful for all the kind of the parties and stakeholders who were involved in discussions to get to that position. So engagement was on a fortnightly basis with secure providers, Scottish Prison Service, the Care Inspectorate, Social Work Scotland, Education Scotland. We also had meetings and discussions with Scottish Courts and Tribunal Service and the Crown Office, and also Police Scotland. So the Judicial Institute were also informed of the changes, and I know the Scottish Courts and Tribunal Service were also engaging with the Judicial Institute around the changes. So that work was completed in advance, and in particular the provisions within the Act around this specific aspect also included the transitions of children from YOI to secure from the date of commencement, and there was a flexibility kind of built into that of a few days until the 31st of August to allow the safe transition of those children. So as you can imagine, obviously there weren't large numbers of children, but we had to make sure that the placements were available for children in secure, and that those were matched appropriately, and also that the transitions took place safely. Two areas that were raised with us throughout the kind of process, and which we're aware of are long-standing issues, are around remand, the payment of remand, and also transport available for children on remand, but in general transport issues. And I'm pleased to say that the Scottish Government have agreed to funding the placement of remand from now on until the end of this current financial year, and future years will be discussed as part of budget discussions that we're ongoing at the moment. So the roles and responsibility for social work in that situation will still remain with social work, to look after the child and to arrange the placement, but the Scottish Government will pay for the actual placement. So that's, as I said, been agreed, and that's a kind of big step forward, I suppose. The process around that was still to be kind of worked through, but we have agreed with the secure providers that they will invoice Scottish Government at the end of every month for the children that are there on remand. So there is an ask for social work in particular to ensure that they let Scottish Government Child Placement Management mailbox know when a child enters secure, and also when they leave secure on remand. So we have that kind of recorded for cross-checking purposes. And discussions have taken place with Social Work Scotland and COSA around that, and further information and communication will be coming out around that. I should also point out that the individual placement agreements that local authorities have with secure providers for children in secure will remain with the responsibility for completion with the social workers, but the payment details will be included in there for Scottish Government. So they're the kinds of details that we've been working through. With regards to transport, which is the other long-standing kind of issue, we currently Scottish Government have a contract with GOAMI, and that's for Scottish Ministers' Responsibility children, so sentenced children. But we have been in discussions with GOAMI about allowing the use of that contract for remand children as well. So that will be on a trial kind of period initially, on a first first come, first serve kind of basis. So we're still working out the finer details with YOIs, and again, further information will be coming out about that. But hopefully that should alleviate some of the pressures that local authorities face around remand transport for children. The other thing that I just wanted to kind of raise with you or bring to your attention is the Reimagine the Secure Care project, which we commissioned CYCJ to undertake for us over the last kind of year and a half. That work's come to an end, and a report is due to be published on the 27th of September. So that report includes kind of options for the future kind of change, and the Scottish Government will be engaging with key partners over the coming months to really kind of analyse and look at those options and come up with a kind of plan for 2025 kind of and beyond, up to 2030 and beyond that. So as you can imagine, that work is gone wider than secure care. It's much wider and more around the care agenda, including health provision, for example. So we'll be in touch with further details about that. But that's some of the kind of preparatory work. And I should point out that the engagement meetings that we've been having with all the key partners, those haven't suddenly stopped because we've obviously brought in the kind of provisions. Those fortnightly meetings are continuing, and that's to ensure that we're addressing any issues and areas that haven't still needing to kind of be addressed, including the kind of transport issue, for example. I'll hand over to Debbie now, who will talk you through some of the practice kind of implications.
Thanks, Liz. So I think we thought it would be quite important for these webinars to talk a little bit about the practice implications. However, that kind of comes with a real caveat of this is not brand new practice. This is building on existing practice. And it's also recognising that there will already be processes for the different steps in a child's journey if they've been remanded or sentenced. There will already be children placed in secure care through these routes, but the key change is that all children who are remanded or sentenced will now be placed in secure care. They will not be placed in YOI. The Scottish Government roles and responsibilities will remain for all sentenced children, and that's a slight change that it will be for all sentenced children. And also, as Liz has outlined, Scottish Government will be funding remand placements, but the remainder of remand roles and responsibilities will stay with local authorities, and that all children who are remanded or sentenced now need to be treated as looked after children. So they are the fundamental changes, but essentially this is building on existing practice that is already there. What it does mean, as Liz has outlined, is where there has been practice challenges previously, as more children are placed through these routes, potentially those practice challenges could affect a greater number of children, which is exactly why these ongoing meetings, dialogue, awareness and understanding of those issues is so important, so that efforts can be made to address them wherever possible. What we thought would be helpful, however, is just to talk through the stages of a child's journey where they have been sentenced or are likely to be sentenced or remanded, and talk about the different practical implications for that. I think it's important just to say this isn't solely about the Act, and this does obviously go beyond justice admissions to secure care, but we thought this just might be quite helpful to help people think through some of the prompt questions and what this might mean for them. So a child's been arrested and a child's to be appearing at court. The local authority should be notified that the child's appearing at court, and that might be via the police, might be via PF asking for information, for example, in respect of bail, might be through Sheriff Clerks, might be through court-based social work. We know there are some challenges with this notification, particularly where 16, 17-year-olds are not already known to services, and there is some work being done to try and work through some of those challenges to make sure local authorities are notified as soon as possible that children are going to be appearing in court. That is fundamental to make sure, one, that those children are supported at court, but two, to make sure that plans can be made for those children if it is likely that that child's going to be remanded in particular. So something you might want to think about locally about is this notification happening consistently? Who's involved in that information sharing? Does this information normally go to criminal justice social work, for example? And if so, how can you ensure that that information is always being shared with children and families? But also thinking about your own organisation. What are your own organisational roles and responsibilities within this? If that child then, so the child's appeared at court or is going to be appearing at court, if that child is at risk of remand or sentence, more than likely you're going to know if a child's been sentenced. Remand are probably the ones that the child might be unknown. It might be much shorter time frames to try and make a decision about remands. Local authorities should be thinking about alternatives there. Particularly should be thinking about electronic monitoring and supervised bail, for example. But also the new bail and release legislation really requires that local authorities are providing more information about bail and about alternatives to remand, but also that the circumstances in which bail can be refused are more limited, and courts need to be really clear, state and record their reasons for remanding someone or refusing bail. So remand, the information to inform remand decisions is really important here. So local authorities need to be thinking about that, thinking about how they can share information on the court about that, and thinking about what their local supports and services and structures are around that. But if a child's deemed at risk of remand, we need to be thinking at that immediate point in time, what does this mean about beds? What does this mean about secure transport? And looking at provisional bookings where possible. So for areas and partners, thinking then is about what alternatives do we have locally for children that can be deployed at short notice? Who's involved in those alternatives? What is your own agency's role and responsibility in alternatives to remand? And thinking about, existing secure care policies, procedures, arrangements, what are the roles and responsibilities for children placed through a criminal justice route, and how are they in place locally? The briefing paper has a lot more information on that. So the child's appearing at court is really important as part of the whole system approach that children are supported before, during and after court. So really local arrangements will vary, but this is a key part to make sure children understand the court process as far as possible, are prepared for the court processes, understand any decisions that are made after court, and are provided with the information and support that they require as part of their journey. So things people might want to think about is who provides court support locally, how is that made available, who makes that available, and how can that be, how can those practitioners be supported to understand changes to the Act, but also how can that information be communicated to children and young people and their families potentially as well. Then if we move on to the next stage of the journey, so the child's been remanded, for example, local authorities' responsibilities kick in there. Local authorities, particularly where the child's remanded to the care of the local authority to be placed in a place of safety. Local authority has clear, and chief social work officers have clear responsibilities there that are really important and need to be fulfilled. Obviously, the responsibility for arranging the placement, arranging the transport and management of the child's placement all remain with the local authority, but as Liz has said, Scottish Government will provide funding for the remand placement. So thinking about what is your existing processes for remand placements, who's involved, how can you make sure that those decisions are made in a timely manner, and recognising the urgency of those placements. So the child's been remanded, they're being admitted to secure care, thinking about what is the preparation and support that children and families need. This really ties in heavily to the secure care pathways and standards, which were really clear about what that support should look like, what children require in those situations, but also thinking about information sharing here. What do the secure care centres, information should secure care centres be provided with, given that they are going to be caring for these children 24/7, that they need to plan how to support those children, and also in terms of any risk management. So this really ties into your implementation of the secure care pathways and standards, thinking about what are you doing round about that, how's that going, what work may still need to be done, and who's involved. The child's been remanded, they've been admitted to secure care, you then get to the point where the child is pleads or is found guilty. Just a social work report is likely to be required. Need to be thinking for those reports about being really clear that YOI is no longer an option for children, although deprivation of liberty and secure care is. Thinking about the Scottish Sentencing Council guidelines and what information the court may require to help them use those guidelines effectively. And then indeed, if that child is sentenced to be deprived of their liberty and placed in secure care, that's where Scottish Government responsibilities for the placement, arranging the placement, funding placement, transport and reviews kick in. So some of the questions you might want to think about locally is who completes justice social work reports. In our recent survey of the whole system approach, it was identified that that might change with the Act going forward, or there might be changes in how 16, 17-year-olds are supported. So something to think about, what does that mean locally? What support do staff completing or contributing to justice social work report needs? And what is the interface between Scottish Government's roles and responsibilities here and local authorities' roles and responsibilities? So once the child's admitted to secure care, be that remanded or sentenced, there'll be the post-admission meeting and ongoing review meetings. Post-admission meeting usually within 72 hours, and the opportunity to share information with the secure care centre, share information, share justice social work reports, children's plans if they've not been shared, but also to think about what does this what support does a child need. At a minimum, there'll be reviews for the Chief Social Work Officer if the child's been remanded. There'll be reviews for Scottish Government reviews if the child has been sentenced. But also, given that these children are treated as if they're looked after children, they should be looked after reviews undertaken on a regular basis as well. And there's a lot more in the briefing paper about that. And our online child's journey resource will also be updated to reflect these changes. Some things you might want to think about is who's responsible. Are these children already part of your existing looked after children procedures? If not, really needing to be part of that. But also, what are other agencies' responsibilities to these children as looked after children? During the child's stay in secure care, it's really important that support is provided throughout, and that child is planned and prepared for their return to the community. Again, this has a real alignment to the secure care pathways and standards, which set out what children should be able to expect, but also the learning from the Care Inspectorate thematic review on the secure care pathways and standards, which still identified some of the real challenges for children transitioning from secure care. And then there's also the part about post-sentence support, recognising that some of that post-sentence support may well be through justice measures. So, for example, release on licence, justice through care, for example. So who provides the support during the journey? Who provides the support when a child returns to the community? How can those relationships be sustained and supported throughout a child's journey? But also aftercare entitlements for looked after children who are placed in secure care, sentenced or remanded, and all children being treated as such. And then finally, as with any new change, there is going to be teething issues here. And we need to be thinking about what is the monitoring and evaluation of this. So how are we going to know locally and nationally what's working, what are the challenges, what are the areas that need further attention, and think about how we can do that either at a local multi-agency basis or what needs national level activity. So that is a very quick whistle-stop tour of changes that Act has brought, I suppose, now that it's been commenced. The changes, what this means in practice, and what was the rationale for those changes. But we've now got about half an hour, well, just less than half an hour, 20 odd minutes to talk through any sort of questions that people have raised, and hopefully there's a few of them on the chat as well.
Thanks, Debbie. So yeah, as Debbie said, we've got about 20 minutes for questions. We've got a couple of questions so far, so we'll work our way through them and I'll try and answer them as best we can. So the first one is from Claire, and it's asking whether there's any further plans for discussion with Police Scotland, Crown Office and Scottish Courts and Tribunal Service, and that's in relation to kind of children in court and children delays, I suppose, to children being brought into court as well. So there's a number of kind of complexities there. So yeah, the answer to that, Claire, is yes, we are. So we actually had a meeting with those partners plus additional partners yesterday morning, and we've got a further meeting next Thursday as well. Social Work Scotland were on that call as well, and they've got some work, some discussions to kind of have from their side with chief social work officers as well. So they're going away and doing that, and we've got, as I said, further discussions to have with Police Scotland and Crown Office and Scottish Courts and Tribunal Service. But that's kind of one key area that has kind of been flagged to us and kind of has been raised as a kind of concern, I suppose, over the last couple of weeks, because we are seeing a shift, I suppose. Those children who aren't on a CSO, who are now classed as children, aren't always known to kind of local authorities and social work. So there's a bit of an issue there in trying to kind of ensure that all the correct kind of processes are gone through, and it links to the whole system approach, which obviously has been around since 2011, and just making sure people know where to kind of go next with some of that. But we are in those discussions and we're trying to kind of iron out some of those problems. So Cheryl, you've asked whether
Sorry, can I just jump in there, Liz?
Yeah, sorry,
just
Debbie.
on Claire's point as well. So there is also quite a lot of work being undertaken regarding the use of police custody full stop as well, and there is some other provisions in the Act that will make some changes round about that, but there's sort of broader activity and focus looking at the suitability of police custody for children as well. CYCJ are keen to support agencies in areas round about that as well, so if we can help, please do get in touch with that. And yeah, absolutely, the availability of secure transport. Hopefully, Liz's earlier points maybe covered some of that as well. So that was just add that in, Liz. Sorry.
No, that's fine. And just Claire, if you want to kind of get in contact with me or anyone else kind of after this, then happy to kind of chat through some of that and just hear what some of the issues are that you're experiencing, because we're aware of a few different local authorities that are having issues, but it'd be good to hear directly from yourself if you want to kind of chat through some of that. Okay, thanks. Moving on. So Cheryl, I've lost the question now. Hold on, let me go back to it. Cheryl's asking about kind of payment for remand and secure transport. So yeah, just to clarify again, the previous kind of process was obviously that local authorities would pay for remand children, and Scottish Government would pay for sentenced children. From the Act kind of this part of provisions of the Act coming in, Scottish Government are paying for remand placements for local authorities. So the actual placement itself and the arrangements for organising that placement will still remain with the local authority, but the Scottish Government will pay for that remand placement, and that's until the end of this financial year, so that's the end of March. The point around transport is that a local authority will still kind of we'll still need to work out the details of how we go about doing this, but if they're looking for transport for remand, then we have a GOAMI contract, which is a child-friendly kind of contract, so different vehicles, and we've been in discussions with GOAMI about using that contract and our current contract for remand children as well. So we're looking to do that on a trial basis. So that would mean that local authorities will be able to use that contract for the transportation of children remanded. So hopefully that clarifies things for you, Cheryl. But I think, as I said, we Social Work Scotland are involved in those, are aware of all of this, and I've got a meeting with them next week just to kind of talk about how we kind of get some of this communication kind of out to all the local authorities and chief social work officers. So they'll hopefully in the next week or so there'll be a bit more kind of detail, written detail for you.
And just on that point, sorry, the sentenced ones, sentenced children, the transport is still funded and the responsibility of Scottish Government. So just to be crystal clear on that.
Yeah, that still continues. So it's just the remand transport that we will hopefully be able to kind of use our contract for, at least for a trial period, and then we'll kind of need to assess it from then onwards. But yeah, the sentence ones will still continue with ourselves. As children are considered to be looked after, do they enter the LAC system and reviewed by LAC review officers?
I can jump in there, Liz, if that helps. Fine. Yeah. So it's just really to clarify, absolutely. So we've got a section of this on this in the briefing paper, but the responsibilities to look after children that apply to other looked after children will equally apply to these children, including the requirement for reviews. How those reviews take place locally in terms of review officers and things like that, that will be for local decision making. But these children should be treated as if they're looked after children, and therefore should be treated in the same manner that other looked after children are. So if that means locally you review by looked after children reviewing officers, then yes. As is made quite clear in the briefing, children could potentially be subject to multiple different reviews through these processes. So there might be looked after children reviews, but also, for example, Scottish Government reviews as the placement manager. So consideration should be given on a case-by-case basis as to how those reviews could be coordinated most effectively, recognising that those different reviews might have similar areas of focus, but there might also be some distinct and different areas of focus as well. So important that those those reviews are coordinated as far as possible. But yes, the briefing paper sets out the different sections of the legislation that applies. And likewise, if that child meets the definition of a care leaver, so ceasing to be looked after on or after their 16th birthday, then they would have access to aftercare entitlements as well, and the existing aftercare guidance would apply in those cases. I note that Murray McGregor puts a similar question, Liz, so I may just caveat that here as well. So absolutely, so the looked after reviews considering criteria and exit strategy, completely appreciate that. Court, it's more at the mercy of court. What I would suggest in those situations, so if the child comes into secure care having been remanded, the initial meeting should be within 72 hours. You might well have the child subject to sort of 7-day remand, or even if the child's subject to a longer period of remand, part of the consideration could be for a bail review if it was deemed that there was a change of circumstance or new information had fundamentally become available. So to some extent, yes, the court could make a decision to change a placement, but that should usually have a level of knowledge that potentially is going to happen round about it. In terms of the early exit for good behaviour that's mentioned there, where the children have been sentenced, their end date of placement would be still the same. So it would be the same considerations and the same periods that would be involved if the child had been sentenced to be deprived of their liberty through any justice route. So those parts would still be there, and there would still be considerations of things like mobility and exit planning and things like that. Again, that would all be discussed and considered as part of the placement reviews that would be managed by Scottish Government in their role of responsibility as children and young people's placement manager. But Liz, I don't know if you've got anything else to say on that.
Yeah, no, that process continues as normal for us within my team. So yeah, I think I'm just looking at the chat. There's no further kind of comments from anyone. We have got a few more minutes. If anyone has anything further they want to kind of ask, and obviously as we've said, we're CYCJ or even myself. If you have any further questions, please drop us an email and contact us, and we're happy to kind of talk through, especially if there's any kind of concerns or any kind of issues that you're seeing happening that we maybe aren't aware of. Then it's always good to kind of know these things so we can try and work through them with the key partners. And Sally's just put in the email address for CYCJ for those that need to contact them. Anything further from anyone? And if not, we'll finish early. It was quite good to get a bit of time back. Oh no, one more. Right, this is from Giorgio. I had a 17-year-old child remanded from Glasgow on Monday. After a lot of confusion in the court, he was transported by GOM. I met him on arrival. He was back in the handcuffed, and it's not child-friendly. No, okay, so this is another issue. So in emergency placement, so if transport hasn't been arranged in advance, then GOM, we've kind of got a bit of an agreement with GOM that they will continue to do as they have done previously in transporting children, but that is, you're right, that isn't necessarily in the child-friendly vehicles, but we're working through some of that with GOAMI, but they've only got certain people trained and certain people vehicles available for transportation of children, and obviously in certain situations there are emergency situations which arise which nobody kind of knows about, and as you say, a bit of confusion at the court. So we are aware of that situation that happened on Monday that the other week, so we've been working with GOAMI around some of that, but thank you for flagging that with us. Alan, outside Glasgow, how will young people get access to specialist forensic mental health services or admitted to secure care?
I think, Alan, that's a fair point, that the FCAM service currently fairly limited to Glasgow and NHS Greater Glasgow and Clyde. There is developments around about the FCAM service specification that mental health colleagues are leading on. And it might be that if you dropped maybe Liz an email, Liz could maybe get some more information from mental health colleagues and could give you some further information about what's happening with the FCAM service specifications.
Yeah, I think I want to say there's inpatient kind of facilities that are being discussed at the moment, from my understanding, and I think certainly one for Glasgow. But I'm sure there's kind of other pathways and discussions ongoing with Dundee, I think, is another area. So I have actually contacted mental health colleagues just yesterday to ask further information, because it came up at a meeting yesterday about kind of the inpatient facility. So yeah, if you want to drop me a message, Alan, and I can certainly find out some more information for you.
The other thing that's maybe just worth mentioning at this juncture is obviously in terms of the developments around about Foxgrove. As much as Foxgrove is not open at the moment, they are still able to give some advice and guidance as well. It's my understanding. So again, that might be potentially another option, Alan, as well. Albeit it's not necessarily providing the specialist service at the moment, but there would be potential options there. And I suppose where we've got the children in secure care at the moment, there is the 3 of the centres are within the NHS Greater Glasgow and Clyde area, so they should be able to access the FCAM service. There's another question.
Yeah, there is. Yeah, Kenneth. Yep. So how will the transition of young people who reach the age of 18 be managed in a supportive manner? So that already happens now, Kenneth. So we have children who are sentenced in secure accommodation who transition to YOI when they turn 18. So we've been doing that for a number of years, and that process starts roughly around 6 months before the child turns 18 to allow kind of that transition process. So that we have good kind of engagement around that already. So obviously there will be potentially more children. So the remand process, for example, children on remand may move. So those processes are already in place, I suppose, just to kind of. But the other point, I suppose, around some of that is that the Act also includes provisions which could allow children to stay in secure accommodation beyond the age of 18 up to 19. Now they haven't been brought into force as yet, but but we are looking at kind of timescales around implementing that as soon as possible, because we are aware of some children who turn 18 and maybe their sentence comes to an end a few weeks later, for example, or there might be it might be in their best interest to stay in secure for a little bit longer. So we're looking at all of that as well. Alan's asked about Foxgrove. You're unable to give consultation at this point in time. Okay.
Thanks Alan, for correcting me there on that. So I don't tell anyone else that part. Sorry, just quickly touching on the 18s part as well. Yeah. Ken, I think it's just that's probably where our remand kind of planning and review process is going to be really important as well. So you might have children remanded closer to 18 who then are, and it would really be getting that sort of transition plan up and running as soon as is possible, as soon as that child's admitted. I think it would be fair to say SPS, Scottish Prison Service, have been really, pivotal in supporting these changes, and I think they're really clear in knowing that kind of pre-18 transition planning stuff is still going to absolutely need to be in place. There's also a lot of information that we know about what helps those transitions and what helps them to work. So yeah, all of that sort of being put in place. So yeah.
Thanks, Debbie. Salwyn. I'm sorry. Yeah, Salwyn has asked a question about if a 17-year-old who was not previously looked after is sentenced to a secure care placement, are they entitled to continuing care upon release up to the age of 21, given it wouldn't be the same placement?
So that I can jump in, Liz, if you want.
Yeah, no, I just wasn't sure about the wouldn't be the same placement, but yeah, sorry, Debbie, yeah, on you go.
So absolutely. So if, say, for example, the child was leaving secure care sort of any time beyond the age of 16, the continuing care legislation does not apply in terms of secure care as such. However, what should be, because you can't provide a locked care placement as part of continuing care beyond the age of 18, but actually what should be provided is a comparable level of care and support. So something not directly continuing care, but it should be within the same principles and the same considerations of this, a comparable level of care support being provided to the child. In terms of, so that's where the kind of continuing care part is a bit different. If that child, say, for example, is sentenced and then is moving on to a custodial placement, for example, or even if they're not moving on to that placement beyond the age of 16, the aftercare entitlements would kick in, and therefore, even if that child is still detained in a YOI, for example, those sort of aftercare entitlements should still continue to apply up to, 21 or beyond. And similarly, if that child, so basically the continuing care and aftercare, keeping them as two sort of slightly separate things. But hopefully that answers your question, Selwyn. Sorry, probably stumbled over that a little bit.
Thanks, Debbie. Okay, any further questions before we come to an end? Eight more minutes. Okay. And as I said, obviously, if you have anything else that comes to mind afterwards, or you watch this again and you think, actually, I've got further questions, then please just drop CYCJ or myself an email, and we'll try and answer those as best we can. But also, as Debbie mentioned at the start, we're reissuing the briefing paper with some of the questions on the back of this session and the first webinar that we did as well. So we'll reshare that. That'll be on CYCJ's website for people to look at. And I think, unless there's anything further from anyone, then we'll end the webinar. And I just thank you everyone for kind of joining, and hopefully that's been helpful for you and kind of clarified a few things for you. But as I said, please contact us if you require anything further or if you need any help, and always happy to kind of chat through kind of any issues that might have kind of cropped up or crop up, because this is all, some of it is new. It is some, new to some people. So yeah, happy to kind of talk through some of that. So have a good rest of the day, everyone. Thank you.